Good morning, YouTube. Good afternoon, actually. My name is Swag Penguin, and welcome to Legalese for Newbies, episode 4. Today I'm going to be starting, this time I'm going to be starting the criminal law series. And now we're putting all the criminal law stuff here. That said, and I have to make the disclaimer doubly so here. This is a purely academic blog series and advice. I am just a legal student. I don't have the capacity or the power to defend someone or leave actual legal advice. If you really do need legal advice, I would suggest getting a lawyer. And that said, let's start, because I make this double disclaimer because criminal law tends to do three things. It tends to affect three principles, and it's rather jarring for people who are going through it. It's to prevent and that has two functions, two main functions: to prevent and control, one of them, criminal behavior, to try and dissuade that, and the other one, and it's very important for this discussion, especially in criminal substantive law, it's different, that the government doesn't go overboard with it controls the punishing power of the government, at least here in a place in jurisdictions that deal very much with Constitution. I'm going to be fast forwarding something from the constitutional series, and that is that in the U.S. and Puerto Rico, because we're a territory, a person can have protection in the constitutional realm and in the state. These will protect against three things: property, liberty, and in cases and in states that do have the death penalty, life. Criminal punishment will have three of these. Will probably deprive you of one of these. That said, the best criminal law isn't just to punish. And a case called Kansas versus Hendricks, Supreme Court Justice Kennedy examines the role of criminal law in rehabilitation and punishment of a known drug user, and I think drug user? It was habitual. He had been a recurring criminal. Okay. And he also examined the justiciability of laws, determining what applies and what doesn't. Why I say that? Because one of the few protections the Constitution will guarantee against in both federal and here state is against an ex post facto law. Ex post facto means after the fact, after the event. In Wonderland, that's not a good thing. In this perfect world, we would be applying the law that applies in the event, at the time of the event. But sometimes laws are enacted, or sometimes they're revised, and that's okay. The problem comes when you try to apply a law that is either too vague or after the fact that the event happened. Remember, these are the three things. There are three factors in criminal law that you must take into consideration about a crime. It has to be coded behavior, tipificado, comportamiento tipificado, in Spanish, behavior that's already in the code. It has to be against the law, antijuricidad. It has to be against the norm, the established norm, mind you, because tradition can be that's another trick, and I don't think there's actual coverage on that from at least the discussion. And it has to have a punish. It has to be punishable. It has to be punished. If you made if you had the crime, if you made the crime, you gotta pay up or serve the time. We're gonna talk about an ex post facto comes in on the first category, which is behavior. Now, according to Dressler's understanding criminal law from Nexis, and Derecho Penal Sustantivo, which is by Chiesa. We have two rounds here. An ex post facto law can be one that is applied after the fact or in between. And the point is that the rule of thumb, when you're looking for a case, you gotta understand that you gotta look for the law that applies best, that best protects the accused from any abuses, and you gotta, not necessarily is it the first one. And usually that means that the first one is going to be a little more lenient, or has less evidence, needs more evidence to prove it because less evidence. And there are three categories that can fall and that can make a law ex post facto. It's any law that is applied after the event and is unfavorable. Second, that it requires less evidence to accuse or to punish, to bring to court. And thirdly, I think it was that it reduced the time it needs to, that it reduced the prescription, the time you need to accuse. I may be wrong in this, but there are plenty of cases out there that do discuss this, that take this matter very seriously. Particularly Rose versus Locke. That one's in California, I think. The point is that one tried to apply vague language about... Oh, and vague language, little drop here. Vague language means that if a person of reasonable knowledge and understanding cannot decipher it, even with a legal dictionary, that is too vague, or it's not specific enough. Rose versus Law deals with that, with applying a law that is too vague for the crime at hand, which was sodomy, I think. But the point is that I will be following up this video in the future, and if you have any doubts or comments, write them down below in the comment section, and like, comment, and subscribe. I have new content every Saturday and Sunday. And as I say every time I close the video, good night, good luck, and and as they say in the Hunger Games, may the odds be forever in your favor. Bye.